Good evening, everybody. We're just going to wait for everyone to join. I think we're up at 30 at the moment. I'll wait until it stops climbing and then I'll start. Okay, it's 5 o'clock, so we're going to get going. Well, welcome to the first of the 3 webinars launches the eagerly awaited Financial Remedies Journal and its associate website. And of course, that incorporates the National Private FDR Evaluator list as well. First thing to say is that the session is being recorded. And my name is Deborah Dinan Hayward. I'm at 36 Group, and this evening I'm hosting this webinar. If you can keep your microphones and videos off, but if you have any questions or comments, we will do our best either to answer them or to sort of set them out if there's anybody who's got a comment. And there's a Q&A panel on the webinar, so just put your comments and questions in there. So I'd like to first of all introduce the panel to you in no particular order, but the order on my screen is Sam Hillis QC. She is a matrimonial finance and family silk in St John's Buildings in Manchester. I try to look for different things to say about our speakers this evening, and Sam's entry states that she played rugby for many years and she sits as a judicial officer for the RFU, Six Nations, the European Professional Club Rugby, and also World Rugby, which I think is pretty cool. So that combines her legal expertise with one of obviously her lifelong passions. Sam is a founder member of the Farquhar Committee, and she extensively contributed to the 2 Farquhar reports. Sam does loads of things, including writing the Financial Remedy newsletter for the judiciary. So she's a very busy lady. So welcome, Sam. Next, we have Joe Edwards. Joe Edwards was previously president of Resolution. I tried to say something, tried to find something that was different about Jo, just rather than looking at her website. And so I went to that well-known legal resource, the Tatler Address Book. And Tatler says of Jo that Jo Edwards is a pioneer in finding less confrontational routes to resolving issues arising on divorce and separation. She guides clients through the process by taking a conciliatory and compassionate approach, whilst always retaining an unwavering commitment to protecting their long-term interests. So very accurate description of Jo. Jo is the head of the family department at Forsters, and she's a member of the editorial board of the Financial Remedies Journal. So welcome, Jo. Next, we have Lucy Loiseau, who's a managing partner at the International Family Law Group, LLP. Lucy is regarded as one of the country's leading young family lawyers. She also has or had a fortnightly radio show on London Greek Radio. Lucy, do you still have that radio show?
I do.
Oh, brilliant.
12 years later.
And on her radio show, she answers all questions family related, and she also has or had a weekly television show. Do you still have that on Hellenic TV?
That one just runs the reruns.
Okay, reruns for that if you want to catch up there. And then finally, Rhys Taylor, who's a barrister in 36 Group and also 30 Park Place. Rhys is a pension guru sitting on the pension advisory group. He's also the co-author of Pensions on Divorce, a practitioner's handbook. He's also a Talata guru. There is nothing that Rhys doesn't know about Talata. He's also vice chair of the Financial Remedies Journal editorial board and the journal's editor. I've quite recently done a private FDR in front of Rhys, and we Private FDR Day. Of course, it's settled because of Reese's very sound indications throughout the day. So it comes highly recommended by me. Reese is also a recorder, a mediator, arbitrator, and in his spare time, he sits on the Family Procedure Rules Committee. So thank you, Reese, for that. Glass Legal are the publishers of the Financial Remedies Journal, and the website, as I say, is part of the Financial Remedies Journal, and it's great to have the backing of Glass Legal behind it. There have been a number of initiatives over the years, particularly over the recent years, with COVID, trying to get a private FDR evaluator list, and trying to also have protocols to make those lists more diverse. Some of our audience may have either come across or heard of Kate Landels, who's with us worldwide, who set out a best practice protocol. And she did so because Kate realised that there was a significant lack of shortlisting or selection of women evaluators for private FDRs, which was in stark contrast to representation of women at the bar and in the judiciary as a whole. We tried to make this evening as inclusive as we could. Not everybody that we approached was able to join us, but I am so delighted to have our guests this evening, and hopefully we'll have a very helpful and useful discussion about private FDRs. Those of you who might have heard me speak before will know that I'm obsessed with something called the National Pool List that comes out every week, and it sets out all the vacancies in England and Wales of courts for deputy district judges and recorders, and it has come out this afternoon, and there are 1,456 courtrooms that are not being filled over the next 3 weeks with a judge. Many of those are financial remedy, and so the role of the private FDR and taking it out of a system that quite frankly is nearly broken and on its knees has got to be a good thing, but it's got to be done obviously fairly. So Reese, very briefly, because I'm going to come back to you, but I consider this to be your project. We had a meeting in last May when it all kicked off, and here we are, March 2022, having a webinar about it. So how did the idea start?
Thank you, Deborah, for that introduction. So the idea for this came about really from Simon Bruce. There was some chatter on Twitter a couple of years back with people making the very fair points that shortlists for FDR evaluators or tribunals didn't tend to be very diverse. And Simon said, well, the way to deal with this is to have a directory so that you can have a look at who's about, who says they're willing to put themselves forward as an FDR tribunal. And so he set about with his secretary in creating a list, and lots of barristers contacted him with their details. A number of solicitors also contacted him with details. And if you were on Twitter and you followed Simon Bruce, you knew that you could contact his secretary and get the list. But not everybody is on Twitter, and not everybody knew to contact. So it struck me that there was this great idea, a really simple idea, because the fundamental point is rather than always going to the same old people, you could look at the list and remind yourself of who was there, and make sure that you had an appropriately diverse shortlist that you propose to the other side. And so it seemed to me that Simon's idea just needed a further shove. And I looked around and no one else was doing an electronic version which would be able to all access rather than having to phone Simon Bruce's secretary. And I approached Class, and they were very interested in the idea. And many of you will know that Class publish a suite of absolutely excellent financial remedy journals and books and the like, and products. And so they seemed like a really natural home to take this idea. And they're very interested in it. And at the same time, His Honour Judge Edward Hess came along and said, well, what about a financial remedies journal? We don't have a financial remedies journal. We now have a specialist court. Surely we've grown up enough in this area of work to have our own journal. And Edward and I's original idea was to have a paper journal. But the very sensible people in class said, well, these days, a lot of people do read things online, you know. And so rather than just making it a paper journal, why don't you have a website to go with the journal? And that immediately married with the idea of a directory. And it's become one of the tabs of the Financial Remedies Journal website, which went live yesterday. So hopefully, I'm not going to show you pictures of my holiday here, but if I show my screen, I'll be able to just give you a sneak preview of what the site looks like. Am I showing that now?
Yeah, you are.
Thank you. And so very, very briefly, once the hard copy journal comes out, which will come out 3 times a year, and we will also post the journal articles into the journal section. We have a wonderful back catalogue of cases organised according to subject headings that are used in the Dictionary of Financial Remedies, also published by class. We've got what we've called a Financial Remedy Corner, the Financial Remedy Court Corner, where all of those practice guides and directions that we've all been trying to keep on top of over the last few months are all in one place. And so that's hopefully a useful resource. We have
okay, so we can, sorry, Reese, we can find like the efficiency statement and practice directions and standard orders all in that corner, can we? Okay.
All of those kinds of things that you know you might be looking around for are all in one place and searchable. We have a blog. Emily Ward has been organising that, and you'll see that we've already we only went live yesterday, but we've already got some blogs up. We'll have latest cases. We've got one of the points that we really want to make sure of is that we report on small money cases. So alongside the big money cases, we've got Miss Justice Peel there in MG and GM, but we've also got Deputy District Judge Arshad there dealing with a case in the family court. We then have the directory and it's not yet populated. We're not exactly sure how people are going to react to this. The idea is if you want to put yourself forward as a FDR tribunal, if you're a family practitioner and you have a certificate of insurance, you can post your details up on the site. And then hopefully if the idea catches on in the way in which Simon Bruce's paper list caught on, it won't be long before there is a searchable electronic directory, and I'll talk about some of the other categories within it a little bit later on.
Okay.
And finally, we've got a little calendar down the side, all of those dates that you might want to remember for financial remedies down the right-hand side. So that's just a very quick introduction to the website, which went live yesterday.
That's brilliant, Reese. Thank you very much for that. I'm going to turn to Joe. Joe, can you tell us some of the problems about identifying private FDR evaluators that you've come across?
Yes, certainly. I mean, I was going to start actually by saying in terms of the broader environment we're working in, I know that this is hackneyed. So one of the problems we all know that we face at the moment is the huge pressure on the family courts. And I do feel from research that I've undertaken myself that over the past 6 or 7 years, the private FDR has really come into its own. But just looking briefly at the most recent stats, we see something like 45,000 financial remedy applications come in front of the court every year on average. About 28% of those are contested, so they do require court times, about 12 to 13,000 cases per annum. Representation, which has fallen off a cliff since LASPO, and then unsurprisingly, it just leads to endemic delay within the system. So we all read the comments of the President last week in which he talked about backlog and delay in the family court and not like dough proofing on a baker's shelf, they have the potential to feed on themselves and grow the longer cases are left without a final resolution. So the backdrop to how private FDRs have evolved is very clear. In terms of the problem around selecting the private FDR judge, I mean, we all are horrified by the work that is being done across the profession. You mentioned in your intro there, Deborah, the work that Kate Landells and her group have done in particular. Yeah. And I have to say, when I look back at the lists that I've put forward and indeed considered when we've been looking at private FDRs, there really hasn't been enough diversity. That's absolutely clear. And so I think having something, this sort of list where we can remind ourselves of exactly who is offering the private FDR service, and being absolutely clear that we are approaching this through a properly diverse footing is really, really, really important, and something that it's time that we stop just talking about and we actually do in practice. So I think this is a really important initiative.
I mean, it's very easy, isn't it, when you're at court and you're sort of grappling around for 3 names to sort of put forward what I would consider to be the usual suspects, which is not necessarily laziness, it's just kind of what you know.
It's habit, isn't it? I mean, I think, within my firm, of course, I talk to my colleagues, we talk to each other about our recent experience. I've done dozens of private FDRs now over the years, so I know about my own experience. We talk to peers, and so we are creatures of habit, and I fear that we do gravitate towards the same handful of names, and clearly that's something we all need to move away from and look at how we might do things differently.
When you talk to a client about the names that you're suggesting, what is their reaction in terms of, do they question the names, or do they just accept normally what you say?
I think obviously it varies from client to client. Typically, they will be guided by us as to the names we're putting forward, or the guidance that we're giving them about names that the other solicitors have put forward. I mean, one of the things I did reflect on, just in terms of diversity of sex of tribunal that we're putting forward, I've certainly noticed there still is, I think, a very lazy tendency to think in certain quarters, if we're acting for perhaps whether it's a wife or a husband, that the non-breadwinner, the person who has stayed at home, has run the home, has raised children, who's putting forward, quite a high budget. I think there still is a tendency, and I'm not saying I accept that this is right, obviously, of people to think, well, if we're going to a very high-powered female silk, for example, will she be able to empathise with my client if this is somebody who's not been working but is expecting to generate spousal maintenance of $500,000 a year or something like that? I absolutely don't think that's the way that people should be approaching cases. Of course, in our professional lives, we're all able to have objectivity and to think carefully about cases, even if they don't resonate with our own circumstances. But I have on occasion, whether from clients or indeed from opponents, had that sense of hesitation given the particular circumstances of the case.
Yeah, thank you for that. I also wanted to ask you about whether when you've embarked on a private FDR, whether you've always entered into an agreement very similar to the ARB FS1 in arbitration. Do you think if you have, should it be compulsory, or doesn't it really matter?
I think there are different component parts to this for me, Deborah. So the short point is, I honestly couldn't remember when we chatted this through as a topic. I was racking my brains to think about my experience on different cases. And actually, when I went and looked back, in very, very few instances have I actually been sent any sort of formal agreement. So what I typically get, understandably, is an email from the clerk of the evaluator in question, if it is a clerk, or the law firm, saying that this is what the charges are going to be, this is when the fee will actually deem, these are arrangements for payment, but nothing beyond that. So I think there are different things that I think would make it helpful to have an agreement. Partly, there's the whole foundations of what a private FDR actually is. So but an hour ago, I was talking with a client about a private FDR coming up next Monday, actually, and was just talking about making without prejudice proposals. And she straight away said, well, what does that actually mean? And so I was having to unpick exactly what the status of the hearing actually is. I think there is also a piece for me around record keeping, and whether if there were an agreement like an ARB FS1, it's a good way of actually keeping track of how many private FDRs are happening around the country. And this has become something of a bugbear for me, I'm bound to say, because we did look at this as a team a few years ago, and we did start trying to collate some stats about what private FDRs are happening around the country. And in doing so, it just became apparent there aren't really records kept. And so it hangs up a very unscientific survey. We approached 5 or 6 of the chambers in London and 1 non-London chambers. And we just asked them over the last 3 or 4 years, what numbers have you had year on year? Number 1, and number 2, have you kept any record of success rates? Now, even the question of numbers, it was quite difficult to discern what was happening. But what was very clear from the people we spoke to was there had been a huge increase over the period of time that we were talking about. Success rates, people don't really seem to keep a record. I guess that's a more nuanced question, because what do you mean by success? Is it success on the day of the private FDR? Is it the private FDR as a tool to success and reaching resolution a week later or a month later? But I think actually having some of that more granular detail would be both informative for the profession, but also something that clients ask about when they're grappling with, do I want to have a private FDR, which I would invariably encourage. They do ask those questions, and I don't invariably have the information to give back to them.
Yeah. Because, of course, you are asking them to pay for something that is ostensibly free in the court system. And so presumably the first question you're asked is, well, why do I have to pay for it, even if it's just 50%?
Absolutely, although I'm bound to say in most of the cases I do, unless we are guaranteed getting a court-based FDR judge fairly soon, and my most recent experience was a 10-month delay in East London, I would invariably say to my client that actually net, it's still likely to be more cost effective to have a private FDR evaluator that you're paying for, but save all of that time when inevitably, as solicitors and indeed barristers know, issues tend to mushroom in the time available. It's far better just to try to nip it in the bud and have a sooner private FDR.
Yeah. And I know that you're very involved in Resolution even now. Did Resolution compile a list of evaluators as well, or are they happy that Class Legal are doing the job?
So it's something I know Resolution has spoken about for quite a while, and I know Resolution will be supportive of this work. There are all sorts of reasons why we've not at this stage moved forward with a list. I think I'm reassured to hear what Reece says about ensuring that people have insurance certificates, for example, if they're holding themselves out as doing this work. But it's something which, because Resolution obviously looks much more broadly at all forms of alternatives to court, our focus has been a little more broad than this particular topic.
Okay, thank you very much. Right, I'm going to turn to Lucy. Hi, Lucy. So how can we promote women non-white evaluators for the list? Is putting somebody on the list that's women non-white enough, or what else can we do?
I mean, I was having a think about this and actually picking up on one of the comments in our chat, and thank you, Matt, for raising the question. I mean, my thoughts on this are, I think that as solicitors, particularly solicitors, we should be getting into a good practice and a good habit of making sure that we put forward lists that are diverse, and some people may not be doing that already, so we need to make sure that we cover those lists and that they're diverse. In the point that Matt raised, and I think it's a very good point, he just says in the chat he was chairing the WIRES National Committee, and they had a simple requirement for no all one gender panels, when you're dealing with things, and it's things like that. It's just making sure that lists, we are aware as solicitors, as barristers, that the lists that we are putting forward are diverse. I think it also extends to when we receive a list, we should look at whether it's diverse, and if it isn't diverse, then you pick up on that and you say, look, it needs to be wider than this. It can't be just so discreet. And I think the other thing we can be doing really is encouraging people, really encouraging, harnessing talent, people that might feel shy or, whatever it might be, just encourage them to apply for lists like this, including areas where there's, been diverse groups up until now. So I think it's about solicitors, barristers just being more open-minded really, and making sure that we ourselves govern what goes out and what we propose, because I think that's where it starts really.
Yeah. As a solicitor, are you more likely to be looking at this list and looking at solicitors or barristers, or what's going to be your criteria when you're looking at a far more wide-ranging list than previously?
I mean, historically, we would choose a barrister from the list purely because there weren't so many solicitor evaluators, tribunal. But for me, the priority is, one, you get someone who knows what they're doing. Two, they're cost efficient. Three, they're going to give you a fair evaluation and an early assessment of your case. And that, for me, doesn't matter whether it's a solicitor, whether it's a barrister. It's making sure that you get the right person to do the job for your client. And I take Joe's point. I think sometimes there is a discussion internally in your teams where you say, maybe if we select this person, they're going to give us a better indication for our client, so let's suggest this person. But I think we need to move away from that, because there's so many people that are capable, and we just need to harness that, really.
Can I just talk to you about the cost? Because I'm sure Reese will go through this on the form, but there is provision on the form for actually to put your hourly rate, or however much you charge for a day. Some people are uncomfortable about putting a cost. What would you prefer?
I would prefer the transparency myself. I think we've got a duty to be transparent. I think that actually it saves you costs in the long run, instead of having to make inquiries as to what people's costs are. There's going to be certain cases where you're going to need a certain level of neutral evaluator, and so it's easy if you've got a place where you can look at what the costs are going to be. You can easily get the information that you can produce to your client. So I would certainly be in favour of transparency there.
Okay, so perhaps filling in that box in terms of how much it's going to cost.
Yeah.
And have you had any difficulties in terms of trying to sell the idea of a private FDR to clients?
Do you know, I would no is the honest answer.
Okay, that's good to hear.
In the last 2 years, particularly in lockdown, I don't think I've had a single court-based FDR. They've all been private FDRs, and we've had, gosh, really probably I'd say a 95% success rate in settling. I just think it makes so much difference where you've got that one allocated evaluator to your case for the day, and they're there to help you. I had heard of a story a couple of days ago where we had a judge that had a list of 6 FDRs and had basically said, I'm sorry, I've only just started reading your bundle, and that had already eaten into submission time. And I think private FDRs, if clients can afford it, I think they're great news for the family profession generally.
Do you think we'll ever come to a time where, as of right, the FDR is taken out of the court system nationally?
Not sure. Maybe.
Because it feels
how the system develops.
it feels like in London that is almost the case, because if you're waiting for 10 months, which you're waiting for a year to get your next hearing, that's not on, is it really?
Absolutely.
Deborah, if I could just chip in.
Yeah.
Of course, the brilliant thing about the FDR originally was getting it into the court system in the first place. My understanding is that the people who set up the new system, originally the pilot scheme, had looked at a very successful model in Australia where they were having what essentially was judicial mediation. But they decided for good reason that it wasn't to be called mediation. And so really a DR process was bolted onto the court process. So to me, it seems very natural that this can carry on outside of the court arena.
And I was going to just add, if I may, I mean, yes, I'm so old. I do remember a time when we didn't have the FDRs and where cases were going straight from first appointment or whatever directions hearing there then was to the steps of the court at the final hearing and only then settling. So it's a really good invention, and it came in 97. I am interested in the thought about being able to mandate private FDRs, much as we talk about whether arbitration may become mandatory. And I know there are contrary views about that. Some people feel, well, actually, as a full paying taxpayer, if that's what you are in this country, you should expect to have a fully funded court system. And even if you pay your £275 for issuing your Form A, you should expect then to have a contested final hearing, whereas others might take the view, actually, why not, if there are the cases that can afford it, why not be able to bounce them out of the system? So I think that's an interesting discussion, debate to have. I know in Scotland, they've also started as I understand it, charging for court hearings effectively a pay-as-you-go court service. So people pay rather more to use the courts in Scotland than here. So not suggesting I endorse any of this with a resolution hat on, but I think these are debates that we will undoubtedly have as the system becomes ever more strained, and particularly financial cases aren't given the resource to try to get them sorted out early on.
Yeah, thank you for that. Sam, can I turn to you? Because I was going to ask you about how things are different in Manchester and the north as opposed to London.
Well, private FDRs are definitely not just a London thing.
Right.
Certainly not.
Good to hear.
Although I didn't know about Simon Bruce's list. So maybe that was something that's south of the border.
Well, Simon Bruce's secretary's list.
Well, his secretary list. I didn't know about that. But I would say that most of the private FDR evaluators that we use are based in London, but we do have private FDR evaluators up north, and we do try and get those on the list. But certainly in some of the higher level cases, people want to use silks as private FDR evaluators, and there are more silks in London, so maybe that explains that. But my experience in the Northwest is that certainly in Manchester, even if not yet across the whole of the Northwest, and especially in the higher value cases, private FDRs now are being considered just as a matter of course. And I was looking at, because we don't have many stats, which I'll talk about in a minute, but I was having a look at my own stats, and in a really short space of time, my number of private FDRs that I conduct as an advocate, not as an advocate, have really jumped. So in 2020, I did about 4 times more court-led FDRs than private FDRs, but last year and this year, more private FDRs than court-led FDRs. So that's been quite a big shift in my own practice. I think there will always be small pockets on every circuit where private FDRs have yet to gain momentum, but I've certainly seen an improvement in terms of the issue at least being debated, even if the decision is then to go for a court-led FDR.
Yeah, and your local judges, Judge Haig, I think, is your financial remedy lead judge in Manchester, is that right?
Yes, it's
supportive.
Judge Haig in Manchester. It's on a Judge Greensmith in Cheshire and Merseyside. There is a great deal of judicial encouragement of private FDRs, and that's also been a bit of a shift. I was trying to think the last time I heard anything negative from a judge about a private FDR, and I'm probably going back about 4 years, and it wasn't even a negative comment. It was really, what's so good about private FDRs? And then you had to sit and explain and say, well, you know, they probably have a day's prep to read it all and get on top of it, and they'll do schedules of assets, and you know, there'll be bullet point indications, and it'll be the only case. And it was quite awkward because we felt all we were doing were highlighting the problems with the court system. But certainly nationally, there is a great deal of judicial encouragement, as we know. There was the Mr. Justice Mostyn's case, AS and CS from last year, and Mrs. Justice Roberts in the more recent case, LS and PS with Q intervening, which dealt with 2 areas really. One, no distinction was drawn between private FDRs and FDRs. So in Mr. Justice Mostyn's case, there was no distinction between them in terms of listing and the requirement to apply to court to adjourn. In Mrs. Justice Roberts' case, there was no distinction in terms of privilege and confidentiality, but both cases heavily encouraged the use of private FDRs. And you know, there are sections in each of those judgments where it said quite clearly that the use of private FDRs is to be lauded because they have a higher success rate, because the private FDR evaluator has more time, and it takes pressure off the court system because it frees judicial resources for those cases which need to be heard in court. And certainly in the Northwest, we have a lot of judicial encouragement for private FDRs for the same reasons. There's a high success rate. it eases demand on the court, but also it eases judicial continuity.
Well, I was wondering about that actually, because that feeds into the efficiency system statement, doesn't it? That you then have that continuity because you take the blip that stops the continuity out, and you can come back to your judge. Hopefully you don't need to, but you've got that continuity there.
Definitely. And what it means is that certainly this happens a lot in Manchester for the cases at circuit judge level, is that the judges in the cases where there's sufficient resources to pay for a private FDR will be very open about it and say, if you decide to go for a private FDR, what that means is I can now timetable this case through, it will remain with me, I will do the next hearing, whether that's going to be a directions hearing just to approve your consent order, or whether it's going to be treated as something of a PTR, and then they can keep it for the final hearing. And also, I think there's an acknowledgement that, and this is Joe's point, whilst you may be paying for your private FDR evaluator, that's the only additional cost. And that's usually more than offset by the fact that you don't have a massive long delay getting your court FDR, and you don't risk things coming out of the list because of judicial unavailability. I mean, that rarely happens in the Northwest, I have to say. I know that we are very lucky because it does happen in other places around the country. But I mean, in terms of success, and I know we discussed this yesterday, talk about the success of private FDRs generally. We don't really have a lot of stats. And again, this is your point, Joe. The new D81 will presumably give us much better data in terms of when cases are settling and at what point they're settling and whether or not there's been an FDR or a private FDR. But just some research of my own again, which may not be particularly exact. Private FDRs, in my experience, have had an 80% settlement rate, and court-led FDRs are just under, just between about 68 and 70%.
Is that in COVID times though? Because my perception is that there's less settlement at a court-led FDR at the moment, because if they're remote, people tend to be less engaged.
Yes, that is all, well, pretty much all COVID. I went back to the beginning of 2020, so not much would have been caught up at in very early 2020 because it was quite busy. In early 2020, getting ready for silk celebrations, and then everything went mad and everything stopped. But yes, they are COVID stats, but I would think they're fairly representative, and I think the fact that I'm neither an unreasonable dragon or a pushover means I suspect that they're broadly representative. I would have thought for people working in my area.
And can I ask you about diversity on the list that you're either exchanging or receiving?
That is something which we've been trying to improve. I was aware of Kate Landell's initiative and have been supportive of that, and chambers have signed up to prepare stats. Now, we book the trend at SJB because we have 2 money silks and they are all women. So when I was able to report back to Kate, unlike some other chambers, I think all of our private FDRs have been done by women in the last 2 quarters. But yes, in terms of the cases in which I'm the advocate, we have been trying to ensure that we have a female private FDR evaluator on the list.
Right, brilliant.
And I think it's important to try and do that. Now, of course, you have to have your list agreed, and so you've got to choose one.
Yeah.
And I also agree with Joe. I find it surprising, but I've heard it before, that the perception is that some wives claiming a high level of spousal maintenance wouldn't want a female private FDR evaluator because they are probably full-time working women, which is just such a bonkers thing to say, because if private FDR evaluators or as advocates, if we had a reputation for only being wifey or husbandy, we'd be out of the market, wouldn't we? Because
We
other
would.
people would be doing it much better than we would. So
Yeah.
I think it's bonkers, but I agree, Jo.
There's a
it
perception.
exists. Yeah.
Yeah, there is a perception. Okay, thank you. Reece, I'm going to turn to you. And are we able to look at the form or?
I'm afraid we're not. So
No. Okay.
as I was saying in the introduction, the site went live yesterday, and I'm afraid that as is always the way with a new website, there's some glitches as we're starting, and so we tried to put a couple of profiles up. We've done that, but there's just a couple of things we want to finesse. So so I won't show the entry page, but it's
Okay.
dead easy. What you do is you go to the PFDR Directory section,
Okay,
and
we saw before.
and there's a nice button that says submit your profile. You click on that and you have to enter your email address, send your email address. That will get sent to you, and you'll get a link to that. Once you've gone through, you've set up your own account. Then you type in your details, your address, the areas of practice. And those of you who are arbitrators will be aware that there was a range of topic headings that you could say that you were interested in and that you profess expertise in. And so there's a similar list of areas of expertise which you can broadcast, and also geographical areas where you're prepared to work. And of course, that will then be useful for people who want to search for those particular skills. There's also a place for qualifications and different languages that you may have. As has already been alluded to, there is the opportunity as well to put an indicative rate into the box as well. And it'll be really interesting, I think, to see how that falls out. I know that there are hawks and doves when it comes to showing the figures. And I know that there are some websites out there, some chambers that do broadcast them, and that's quite interesting to see.
Well, the QEB publish all of their rates,
yes,
don't they?
They do. Yes.
Yeah.
And so I know that that's very helpful. I think there is a perception sometimes that if you put your indicative rate, then that doesn't allow your clerk to do what your clerk does.
You're stuck with it.
which is to perhaps give a loyal solicitor a particularly good rate in a case. So it may well be that people think that these are out of their reach, but they may not be. And so, it's a competitive market. And so if you broadcast a rate, you may be putting people off. And that if you just picked up the phone and spoke to the clerk, then, people may be surprised. But so there are arguments going both ways as to, what the, whether or not.
Yeah.
And I'd be certainly very interested to see, what gets broadcast in due course. And so, there's an opportunity. You can also put a photo up, and then hopefully, if lots of people do that in the coming weeks and months, we will have something that approximates a Technicolor version of Simon Bruce's Secretary's paper list that will be searchable and accessible to everyone. And of course, one of the other features of the last 2 years, because 2 years is now upon us in terms of the different way in which we've been working, is that lots of these have been done remotely. I know lots of people have done them with clients abroad and things like that, and so there's huge amounts of flexibility in terms of where people are and where tribunals are, and so just because someone's based in the northwest, for instance, there's no reason why they can't be doing a private FDR in the southeast, but remotely. So,
and looking at it from the other perspective of somebody who wants to search the list to get 3 names or 5 names, they're going to be able to put in certain requirements and get that list thrown back at them. Is that how it's going to work?
Sorry, Deborah.
In terms of the person receiving the list.
Yes, sorry,
Yes.
sorry. I was looking at a. I'm terribly sorry. I was looking at a question that was coming in on the chat.
Multitasking,
I
Reece. You
missed
can't
it.
do
I'm
it.
terribly sorry. No.
So I was asking in terms of the person receiving the list. So you're at court. Somebody suggests private FDR under the efficiency statement. I think actually the efficiency statement talks about the name of the private FDR evaluator being in the order, or at least discussed in the order. So you wanting a list, you're wanting those names. You put your requirements in and you get a list thrown back at you, or what do you receive?
So we are finessing the final parts of this directory now, and so I know there's a couple more gizmos that the designers are just looking at. So the final look of this bit of the site, I'm afraid, we're going to have to wait a day or so. And we've been frantically working today trying to get it ready for tonight. But I'm afraid
Okay,
we can send out a link. We can send out a link to delegates once it's all up and running, and then they'll be able to click and see what's there.
Yeah, great. Because I think we are meant to identify our evaluator, if that's the route we're going to go down, before we notionally leave court, whether that's virtually or in real life.
Well, of course, you need to identify them, don't you? Because you'll need to fix it so that you've got the date for the next hearing. And so when I've been dealing with cases and we've been directing private FDRs, the judge wants to know the identity of the private FDR evaluator, but more importantly, needs to know when it is so that we can direct everything else.
Yeah,
so,
and sort of work back.
Those details do really need to go in the order.
Terribly sorry. Hannah is reminding me that the search criteria, you can narrow the search criteria. So if you've got very sort of particular requirements, if you wanted a Greek speaker, for instance, you could narrow your search on something like that. So there'll be different ways of searching it.
So I was just going to chip in, if I may, on a related topic with my broader DR hat on, and we're talking here so far primarily about private FDRs in the context of a court process and the next court hearing, but of course it's not exclusively the case that there is a court process to mean that a private FDR will be beneficial. And I've certainly had cases whether couples in mediation who want that steer who I'm working with, or where there's voluntary negotiations and they need a steer. So I just wanted to flag the point, and I know it's very well known to those watching, that it doesn't just have to be in a court process that this is useful. And I think increasingly couples are using it in other circumstances as well, which I find really helpful.
I agree, Jo. I've used it out of the court process as well. There's been voluntary exchange of Forms E or another format of disclosure, and gone to a private FDR without proceedings being afoot.
Yeah.
Just looking at some of the questions, Dave Emerson says, do you think we'll end up with a legal 500 chambers category for private FDR performers? So almost like a sort of TripAdvisor rating. Do you think we'll have that, depending on your success rate? Lucy, what do you think?
Not sure. I find it a little bit crass, to be honest. I mean, I know Legal 500 chambers is, people are ranked, and in that I think everybody's got their different skill set. Are there going to be rankings of how good an private FDR evaluator you are? I'm not sure.
I mean, chipping in, I hesitate to disagree with Lucy because I have a huge amount of respect for Lucy, but actually I think it's a really interesting idea, because something that at Resolution we talk about quite a lot, for years the focus of these directories has been the people who take the biggest cases to court and have them reported, whereas actually, sounding a bit evangelical, there are really good lawyers across the country doing really good work to resolve cases who historically wouldn't get that recognition. So I think it's a good idea in principle. I think my question mark would be, what are you actually evaluating in looking at the directories? How do you decide that somebody's a better private FDR evaluator than another? But I think it's an interesting idea that we definitely need to pull, I think, these directories kicking and screaming to look at different measures of success, actually.
So certainly Andre Bajarski is making the point in the chat that the directories do have these sections for commercial arbitrators and mediators. So, you know, it's not, there is a template
and family mediators now as well in some of the directories. So there is a template there even within family.
3 points for a win, 1 point for a draw.
2 points if they settle within 3 days.
Yes, right, exactly.
I did do, Andre might not remember this, but I did do a private FDR in front of him, and we were there so long that the wife put the kids to bed and came back to carry on negotiating. We were there right into the evening, and you never get that in front of a judge. No judge is going to hang around in the evening, so definitely think it's a good system. Has anybody else got anything to say that we haven't covered, or anybody got any other ideas in terms of increasing diversity?
I'm being far too chatty, but just one other thing that
Not
I
at
wanted
all.
to raise was the unrepresented parties. And again, it's another slight bugbear of mine. I mean, I have plenty of mediations I do, and I'm not publishing to the whole world that I have unsuccessful mediations, but on occasion I do. And I find increasingly I'm getting couples coming to me who can well afford to have separate legal representation and advice, but for whatever reason choose not to. And they get to the end of my process if they haven't resolved things. And actually, if they're unrepresented and fully unrepresented, they genuinely struggle easily to move into a different process. So most logically, I would signpost them to arbitration if we think that an evaluation, a neutral evaluation, isn't going to move the dial. But my experience is at that point, the conversation breaks down. So I've got a couple at the moment who have been trying for about 3 months to get them into an arbitration. But because they've chosen not to be represented, they're really struggling. So I do wonder what the place of unrepresented litigants is within the private FDR process that we're talking about. But I don't have an answer to that.
No. Sam, do you have an answer to that?
No.
Reece, do you have an answer to that?
You're honestly useless panel.
Yeah, I know. I was thinking about litigants in person because it just would be so perfect for them. You know, it's cheap, it's much faster, everything's good, but it's quite difficult to actually get them into that process. It's lawyer driven at the moment.
Yeah.
The interesting point from David Emerson coming in on the chat as well. Dispute Resolution Committee is interested in some form of quality around evaluators, but would not want the responsibility of monitoring or evaluating. So, and the market does tend to find people out, I suppose. And if you're you're grumpy or unprepared or not willing to sit after 5 o'clock or very pro-wife or very pro-husband, the market, word soon gets around, I think. But quite how one formalizes that is perhaps a little bit more.
But I suppose the thing is, Reece, with what we're proposing is a far more diverse list. And so you're talking about a system that contains what I would call the usual suspects. And now we're going to completely broaden that. So that reputation is not going to be the same as it was. The broader we throw this net open.
Well, perhaps once the directory is up, if we get lots of people sign up for it, we could have like some little, some TripAdvisor. We could sort of give 3 stars or 2 stars or something.
Thumbs
like
up
that.
and thumbs down.
Yes.
But it would be. I mean, I think I agree that some kind of feedback system might be useful, but what criteria by which would we measure it? I mean, a successful private FDR is one that leads to a settlement. It's that binary, isn't it? I mean, people have to have a good experience, but that's the measure of success. So I'm not sure how we could have some kind of general evaluation system, certainly not something on the Financial Remedies Journal. And
it was a joke.
As a
Sam hasn't taken it as a joke.
Evaluating it, but I do think probably Legal 500 and Chambers will be the way in which these things are certainly mentioned and in people's profiles. I mean, we've all got probably at the same time now, haven't we? We're all dealing with Legal 500 and Chambers at the minute.
Yeah.
Perhaps we should mention to the Legal 500 and Chambers researchers that we speak to about private FDRs, and at least get it on the agenda for them to consider.
Yeah,
I agree. I mean, I think it goes hand in hand with the stats. I mean, certainly my experience of speaking to journalists over the years about private judging, private justice, is they're really interested in it. But the first thing they want is stats underpinning it. So I wonder whether with the directories as well, until we've actually got some more concrete data, we can talk in terms of anecdote, and hopefully if they're hearing it from enough people they're speaking to, that will be enough. But they may want a bit more, perhaps just underpinning what's going on.
Yeah. Well, maybe we do have to start keeping stats in a way that we haven't previously. Or, you know, anybody, all firms, all chambers. Maybe that's the
I think
solution.
are starting to now, aren't they? Because of Kate's
Yeah, because of
initiative.
Kate's
There
list.
are
Yeah.
quite a few chambers who are keeping stats, but generally, I mean, as we know from our work on the FARCA committee, the current method of collecting data at the MOJ doesn't really work. It's not really particularly useful.
Well, Sam, we wrote off London because it was so inconsistent.
Yeah, it's coming up with some odd figures about how long it was taking cases to finish that we couldn't quite believe. Certainly the new D81 and that category which says, you know, how have you reached your agreement? And I think it gives a couple of tick box
Yeah.
options and then an other. That will certainly help. But that's going to be quite a slow process, of course. We won't have the outcome of those until the new D81's been running for a while.
No, I think Michael Allen says perhaps the new D81 could record whether a settlement was reached following a private FDR.
You would expect people to include that information, I think, in the other box. It doesn't say specifically whether the agreement's been reached at an FDR or a first appointment. I think it's more whether it was reached by discussions between yourself or negotiations with solicitors or other out-of-court settlement. But the other box, I think, will be completed, and people will say if it's private FDR or FDR there, hopefully.
And maybe it's the way quite often now we might have it recorded on top of an order that following a private FDR that took place on X and X date, a settlement was reached. Maybe that's the way the MOJ can gather the information. I mean, I don't know, there must be a central record somewhere. I don't
Could I just mention as well, as I see that 6 o'clock is creeping up on us, and the website is financialremediesjournal.com, and we're really keen to hear from you. There's a blog that you'll be able to send in your thoughts and your ideas. We're very keen to hear from you. And then there's the 3 times a year hard copy journal. If you want to write something a little bit longer and a bit more article-y-ish. So, you know, there's a blog there, and then there's the deeper article for those who want to write heavier things. So have a look at the website and follow us on Twitter. Let us know what you think of it, what's good, what's bad, what might be improved. And yeah, we'd be delighted to interact with you.
Well done for everyone for getting this up and running. The website looks great. The whole team.
Yeah, it's amazing.
Everyone, well done. Well done, guys. Looks brilliant.
And as they say in podcast world, like, subscribe, and tell your friends. Thank you, everybody. It is nearly 6 o'clock. It's been a really interesting discussion. I hope that we'll be able to revisit this again with far more diverse lists than we have had hitherto. So thank you, and have a lovely evening. Take care. Bye-bye.
Bye.